You're welcome back to the Pulse on the Joy News channel on Multi TV. Now, as we mentioned at the top of the hour on the program, the Supreme Court had ordered government to produce Ghana's agreement with the United States of America, which informed its decision to admit into Ghana the two former inmates of the Guantanamo Bay. You will recall that early this year, two private citizens, Margaret Banfo and Henry Nana Boakye, sued the Attorney General and the Minister for Justice, together with the Interior Minister, and accused the President of illegally bringing into the country two former Gitmo detainees in contravention of the laws of the state. Well, the plaintiffs sought, among other reliefs, a declaration that on a true and proper interpretation of Article 75 of the Constitution, the President acted unconstitutionally by agreeing to the transfer of Mahmoud Umar Mohammed bin Atef and Khalid Mohammed Saleh Al-Abdubi into Ghana. Well, joining us in the studio for more on the story is Nana J. Bafro, a lawyer for the plaintiffs. He was in court today, saw things for himself at first hand, and also heard the decision of the court. Will give us a bit more details and see what else will be done beyond the directions given by the courts. Thank you, sir, for joining us here on the program. So, what happened in court today? Let's start with that.
Basically, the court was ruling on earlier proceedings, which had been consequent upon an application to the court that the AG's office is made to disclose the agreement for saying to be used as evidence in the case. The AG's office had been, the Attorney General had been in opposition to the production of the agreement, but of very essential of serious relevance to this matter had been the fact that the AG itself, when the matter first broke, had denied that there was any agreement and that this was just a diplomatic handshake. And so we formed the view that an agreement does not really matter the form in which it takes. Otherwise, governments would circumvent constitutional scrutiny just by saying that this was through diplomatic handshakes. But regardless of whatever form it takes, we are of the perspective or the view that it ought to come within the scrutiny of Article 75 of the Constitution. And so we went to court. When we went to court, the AG then subsequently filed a statement of case or a response in opposition to what we had filed, to the effect that, yes, there is an agreement. However, it was one which was entered into by way of note verbals. You know, those of you who are familiar with note verbal, you know that it's just memorandum, you know, exchange, you know, unofficial exchanges, which are not even signed. And so the AG said, look, we have an agreement, but it was entered into through note verbals. However, they are of the view that it is one that does not come within the contemplation of Article 75 of the Constitution, and therefore did not require parliamentary approval. They also went on to say that, yes, we have come to court, but even after we have come to court, or even before we did, the agreement which formed the basis of our suit was not even available to us, and therefore, to the extent that our case is more of documentary, right, same should be thrown out or dismissed because there was no evidence to support our cause. Now, we formed the view that that was very insincere on the part of the AG. It's just like you holding a butterfly and then going to an elderly person to say that I'm carrying this butterfly in my palm. Is it dead or alive? And if you say it is dead, then it would, you know, free it to fly away. But if you say it is not dead, then it would strangle it in his palm, and then the butterfly will die. So we brought an application to court to say that, look, per the rules of litigation in Ghana, there's nothing like ambush litigation anymore. If there is any document which is in my custody for which you think will be relevant or necessary, will be relevant and necessary to the determination of this matter, you can apply. So we are making an application because we think that the agreement which they have admitted to be in their custody is relevant for the determination of this matter, and therefore same must be applied. Same must be ordered to be disclosed. Now, the AG then came to court and say, they must win their case on the strength of their own case. So if they don't have the evidence, the case will be thrown out.
Okay.
Apart from that, the agreement is protected under the State Secrecy Act, and therefore, Section 1 of the State Secrecy Act, and therefore, the court should not order a disclosure. And subsequently, it's a confidential document that would, that would, if disclosed, would be a threat to national security. And so we came under Article 135 of the Constitution, which is to the effect that the mere assertion of such defenses or protections should not mean that the agreement, they should be precluded from disclosing the agreement. However, the Supreme Court would have to examine it in camera. So there was an in-camera, based on that argument, the Supreme Court ordered for an in-camera hearing. So there was an in-camera hearing. And then during the in-camera hearing, we made submissions to the effect that all the defenses from what we had seen in the agreement, which I can't disclose, all the defenses they had asserted were non-existent, and therefore the Supreme Court should order a disclosure. So after that, the Supreme Court adjourned the matter to today for a ruling, and then they came to rule that, look, they side with us. The defenses that the AG had asserted were non-existent.
So, per disclosing the detail of this agreement, will it mean that it will be open to every Ghanaian to see it?
No, it is just limited for the use of the lawyers. After all, the matter is being adjudicated upon by the court.
Yes.
Of what benefit will it be if it comes out? But very, very importantly, what is fundamentally important in this decision is this. The AG didn't want to produce the agreement in court at all.
But he did eventually, didn't he?
But by virtue of the court order, it has done it. Now, the victory in this is that government cannot simply say that I will not disclose any agreement simply because it's a confidential agreement. The rule of law will prevail in that the court would have the jurisdiction, the exclusive jurisdiction under Article 135 to examine such an agreement to determine whether or not the defenses or the protections that government will be is asserting, be it the protection under Section 1 of the State Secrecy Act, confidentiality, national security, and so on and so forth, exist, before it can make an order that government should not disclose it. The victory, as I said, is in the fact that government cannot say, I will not disclose at all.
How they do. Okay, yes. So for me, I'm just looking at it. Two private citizens go to court, they want the details of this agreement, they get it.
Yep.
Why can't it be shared with everyone? Because I'm sure many people have followed this with keen public interest.
I think it's based on the circumstances of the case. But I do not think that another citizen cannot get it if you make an application to the court. Because based on a recent decision in the bus branding case, an order was made by the court for the bus branding agreement to be disclosed to the public. So I believe that independent of this case, it may be possible.
Okay.
But in this particular case, the court is saying that, look, you've brought this matter to court. We are supposed to adjudicate upon it in court. And therefore, we have ordered that they bring it for the use of the stakeholders, of the parties in court.
So by stakeholders, you mean the clients, your clients who asked you to file this, for which matter it was heard?
The lawyers.
Just the lawyers?
It says that for the use of counsel.
So the two citizens who hired your service to get this will not see the document?
Once the Supreme Court said for the use of counsels, in my perspective, it precludes them.
Okay, then you see, then that comes back to the question I was asking before, because the understanding all of us got was that if two people have hired the service of a lawyer that they want to see the agreement, the court says show it to the lawyers, but it's for the counsels. Then how does it benefit the ordinary Ghanaian?
The significant benefit to the ordinary Ghanaian, first and foremost, is this: is a very important decision, to the extent that government cannot say, I will not produce an agreement or a document in court simply because it's state secret. This is of precedent value. The second point is that a decision by virtue of the disclosure, we will be able to prosecute this matter very well. Having seen the information contained in there, to come to, to assist the court to make a determination as to whether or not the agreement, the Gitmo agreement, is one which ought to have gone to Parliament. Because you see, one of the arguments that Attorney General has made is that even if you go to the United States of America, it is possible for the President of America to enter into an agreement without international agreement, without recourse to Senate. Okay? But when you look at the United States situation, which is the exception in the United States, there is an exception to it. The exceptions are that, one, the agreement must not be of a kind that binds subsequent governments. It must not again be of the kind which infringes on the fundamental human rights of anybody. Thirdly, it must not be of a kind, okay, which would affect the national purse. So there are several exceptions to that. Now, having seen the agreement, we are in a position to say that, look, yes, first and foremost, constitutions are made or limited. The interpretation of a constitution is limited to the people, the circumstances of the people, and so on and so forth. So you cannot use the constitution of another place to do that, to interpret that constitution. But very essentially, even the place where you are saying have got such exceptions, they have exceptions to that. And in our perspective, having seen the contents of this agreement, those exceptions, we come under those exceptions. So those arguments are not tenable at all.
So to wrap up the conversation, sir, is that to mean that what you've seen in the document, there was every reason for this agreement to have gone to Parliament for approval?
Yes. It doesn't matter the form it takes. It should have gone to Parliament. And I think that, we need, as a country, serious constitutional reforms. It will be dangerous one day for this country under the current constitutional dispensation to fall into wrong hands. We will be dead.
Why do you say that?
I won't say much. We need serious constitutional reform.
See, to say this means that there's something you know.
We need serious constitutional reform. We need serious. There's so much power in the hands of our president, and it's not good.
Why do you say so?
It's obvious. Under our constitution, the power is not extensive. The powers of the president are not extensive.
Yes.
Is it good?
You think it's subject to abuse, and that should
Yes. Yes, and we need serious constitutional reforms.
Okay, all right. Thank you, sir, for your time. Clearly, this case is one that we will follow closely to see what happens. And as he's explained that if this agreement should have gone before Parliament for its approval before it was signed, it has far-reaching implications for us as a country. We will explore that sometime later. But if you forgot, today is actually the final day for the re-registration exercise taking place across the country. The exercise is taking place alongside the exhibition of the voters register, and it was necessitated by the deletion of some 56,000 voters who registered using the NHIS card as a form of identification. Those turning up to be re-registered are less than half the number that was deleted. Well, on the last day, which is today, my colleague Jennifer Kramwa has gone around checking the rush to meet the deadline ending today.
This is the last day of the re-registration exercise, which was authorized by the Electoral Commission to ensure that all the voters who registered using their NHIS cards would be able to re-register and be franchised for the elections. We're at the A1 polling station at Advocacy, and we're finding out whether more people have registered or if the numbers are still low. Madam, good afternoon.
Good afternoon.
Please, can you tell me your name and the name of the polling center?
My name is Adiza Tujibro, and this police station name is A1.
Since today is the last day, have you seen a lot of people coming here?
Yes, but we have 6 for the re-registration, but only 2 people have come to verify their name. So we just direct them to the EC to check so that they can get their name re-registered.
But then, can you please check your roll? How many people are supposed to register here?
644.
And out of the 644, how many have registered?
260.
So what will happen to the other 400?
We have more days left, so we are hoping they will come. So if they don't come, then we don't know what will happen. So
Can you please tell me the name of your polling center?
It's Nayak Polling Center. Yeah.
So since the checking for the re-registration began on the 18th, have a lot of people come to check?
For now, we've not really had many people coming to check their names. We just have once in a while, you have one person coming through actually. Then I think, yeah, that's all.
But do you think it's because maybe people don't know that they're supposed to come and check to make sure that they're on the register?
Actually, the fact is, most of them, when they come, they ask, when are we ending the whole process? And when you tell them it's on the 7th of next month, then they'll tell you, oh, then there is more time there's more time. Even if you tell them they should come and check, they will tell you they are busy and all that, but they have more time to come and check. Yeah, so probably that's it.
That means people think both the processes are ending on 7th August.
Oh yeah, sure. So we had several people coming here for us to explain to them that the whole thing is not ending today or tomorrow or something. Yeah, so we just explain everything to them. Yeah.
So far, how many people have done the checking?
And so far, we've had about 194 people checking out of 500 and I think 96.
So what's going to happen to those who haven't checked? The difference of about almost 400.
Well, I think let's see what happens till the last day, because I'm sure during the last week most of them will be coming.
Can you please share with us the numbers of those who have checked so far?
Yeah, from A, the normal check so far is from A, from Monday. I'm talking about this Monday up to yesterday, it was 84, and then B is 80, D is 62. But the C, the figure, we were not having it simply because the one in charge, she said she left the numbers in the house, and so
the kind of things you hear sometimes. But anyway, let's get a quick update from the Electoral Commission on the numbers of individuals who've been able to re-register on the last day of the exercise. Mr. Eric Jakpasu, Head of Communications for the Electoral Commission, joins me now on the line. Thank you, sir, for joining us. A quick update. How many more have registered as of today?
Thank you very much. The exercise ends today at 6 p.m. We are in the process of gathering the data from the field, and we hope by late this evening we'll finish gathering the data. And tomorrow at our scheduled press conference at 10:30 a.m. at the conference room of the Electoral Commission, we will update the Ghanaian people on the number of persons who have been able to register.
Okay, but for the last figure you got from yesterday, what number are we looking at?
I wouldn't want to make any projection now because we will be talking about definite figures in just a few hours' time. So I would advise a little patience so that we gather the data and then tomorrow we can come out with a definite figure.
Mr. Hemasu, I get you, but I just want some clarity here. The last time we checked was about 19,000. There's 56,000 to re-register. Are we even close to 50,000?
Let's just, it's not too far away. The time for the press conference is not too far away. I don't want to put anything out there for now. To be before tomorrow we'll start putting out different figures. So let's just wait and tomorrow we'll get through with all that we have.
But there's one thing clear, that a lot more individuals have not come to register.
If we take what you are putting out there for now as something to go by, then we can say that yes, some people have not been able to come to register.
And for today, let me just understand this. By 5 p.m., the polling stations may have closed. What happens for individuals who come at the very last minute to have themselves re-registered?
Yeah, the registration centers are scheduled to close at 6 p.m. But you know, the way electoral processes work, if by the close of 6 p.m., there are people still hanging around who haven't registered, district officers and registration officers have been sacked, and in fact, they've been doing it all this while to work and to such time that the last person is registered.
Okay,
and what happens? And what happens to people who will not be able to register during this exercise will form the substance of the press briefing tomorrow.
All right, thank you, Mr. Dekasu, for your time and that update you're giving us. Clearly, we don't have the numbers yet. We'll get that tomorrow. But one thing is evident, that the turnout has been low. Let's see what the EC does about it as the re-registration exercise officially ends by 6 p.m. today. Now, Pressure Group Research and Advocacy Platform have begun the collection of signatures to petition the President, John Mahama, to exercise his powers under the Constitution to grant pardon to the Mentia trio who were jailed yesterday for threatening to kill some Supreme Court judges. Razak Abu is the convener of the platform. He joins me in the studio for a quick chat on this drive that you're on. Thank you, sir, for joining us today.
Thank you.
So, what's informing this call for signatures to be signed on this for the petition?
All right. Thank you so much again. Good evening to you and good evening to your listeners.
If you could just speak up, please.
What informs this call is born out of the fact that yesterday there was a jail term handed to 4 citizens of this country, and then we think that the jail term that was handed to them shouldn't have happened. It was excessive, and to the best of our understanding, what happened was lawful. And then, because it came from the Supreme Court, and we are asking the President to also do what is lawful, to grant them pardon, because in our view, what was handed to them was really excessive.
Okay, so is there your understanding that if the Supreme Court takes a decision in its wisdom on a matter of contempt for any other individual which is deemed excessive, you will step in and push for the pardon to take place?
No, not any other person. What is happening now, we are saying that it's an affront to free speech. We are not saying what those guys have done is right. It's condemnable, and many people condemn it. And those guys themselves, apologized, both outside court and in court. So what we were expecting was, a sentence that that would be commensurate to what they had done.
Okay, so
especially when they had been convicted.
Who's measuring? Is it our own understanding of what it should be, or a discretionary power in the bosom of the judges that they've exercised?
It's because this is a matter that affects free speech. You know, the judiciary is only an arm of government, and the other 2 arms, all the 3, come under us, people of Ghana. We have empowered them to exercise those powers on our behalf, okay? And we have a right to free speech. So we are saying that if somebody, exercises that right beyond a certain level, yes, the Supreme Court or the law can call that person to order, but to criminalize free speech, and if you remember, we repealed the criminal libel law to be able to open up the media space. So if that was done, how come that we now have another animal called contempt to use to criminalize free speech?
But sorry, Mr. Abu, contempt has always been there for a very long time. The fact that it may not have been activated does not mean it's a new animal in the room haunting anyone.
No problem. We are not saying it's a new thing. At the moment, our call is that what is being used for is far in excess of what should be done. For instance, the guys have been convicted. Conviction is punishment enough. For instance, if they are going to apply for a visa or they are going to complete forms for employment or anything, it will be in their records are people who have had criminal conduct. That is punishment enough.
Okay.
But go beyond that, a fine or something, moderate is understandable. But to give them 4 months in jail for speaking their mind, in our view, is excessive.
But are you weighing this against the comments that were made, threatening to kill judges in the country, in certain instances, suggestions of sexually abusing a judge? Don't you find these comments not just as out of line?
We are not justifying,
threatening the whole integrity of the judiciary.
Nobody is justifying what they said. They said it's condemnable. nobody is justified.
Is it just condemnable? Or it is
condemnable, is punishable, but we are saying that the punishment at the moment is excessive. That's the operational word.
Okay.
It's excessive.
Okay.
And that is why we are asking the president to come in. We are not asking the president to go outside the law. What the Supreme Court has done is within the law. All right? But we are asking the president to also use what is within the law, all right, to pardon them. And the pardon process, you know, is in stages according to Article 72 of the 1992 Constitution. And with your permission,
unfortunately, I don't have the time for us to go through it, but I guess the point is, how many signatures are you looking to have to push this petition through?
If we get in excess of 1 million, we can present to the president.
Okay, how soon do you want that done?
In the next few days.
Okay, all right. Yeah. Thank you, sir, for your time today. Razak Abu is the convener for the Research and Advocacy Platform. They're pushing for the release of the three. They feel that the judgment by the Supreme Court is excessive. Even though it is punishable and condemnable, they feel that it's excessive, and the president should step in on this matter. We'll go for a break now. We'll come back and bring you sport here on The Pulse. Stay with us.